Ladies and gentlemen, let me welcome you to this program on litigation for legal secretaries. To those of you who are not familiar with or accustomed to these premises, let me welcome you to Osgoode Hall. It's the home of the Law Society of Upper Canada, and indeed the seat of the courts, the Court of Appeal and the Divisional Court sit in this complex. I can tell you that last year, in 1982, was the 150th anniversary of the use of Osgoode Hall by the Law Society. Convocation, the benches of the Law Society, first met in these premises, not here, but in part of the complex, in February of 1832. We're proud of these premises, so welcome to Osgoode Hall. Now, I recognize that I'm not known to many of you, so I'm going to take the unusual step of telling you who I am. My name is George Collins Williams. I'm the Director of Continuing Legal Education, employed by the Law Society of Upper Canada in that role. Prior to coming here some 7 years ago, I had the pleasure of practicing law in the city of Toronto for 28 years. I'm getting old. Now, with that, you don't need to know any more about me. What I am going to do is spend a few minutes talking to you about a subject which I'll mention in a minute. Then I am going to introduce your chairman and hand you over to your chairperson for, I think, and I know, a very interesting and useful morning. First, I want to take a few minutes to talk to you about a subject which is most important to you in the role which you occupy in the delivery of legal services. Your role is one of great responsibility. You have, I don't need to name them, you have responsibilities to the person for whom you work, the lawyers for whom you work, to their clients, and indeed to everyone with whom you come in contact while you're doing your job. Those responsibilities include obvious things: honesty, reliability, competence, fairness, initiative. You've got to be self-starters. You've got to be able to think and get yourselves going. But there's one particular responsibility which I want to zero in on for you for a few minutes, and that is the responsibility of confidentiality. You are working with, in every case that you work on and every file that you deal with, you are working with people's secrets. You have to maintain confidentiality with respect to those secrets. Let me read to you rule number 4 of the Rules of Professional Conduct of the Law Society of Upper Canada. Now, this rule, of course, is talking about, it says lawyer, but you know as much about the client's case, or 97.9% of the client's case and secrets, as does the principal for whom you work, because you run the file. So, when it says the lawyer, it should say the lawyer and the legal secretary. The lawyer has a duty to hold in strict confidence all information acquired in the course of the professional relationship concerning the business and affairs of his client. And he should not divulge any such information unless he is expressly or impliedly authorized by his client or required by law so to do. You share with the lawyer and the lawyers and the firms for whom you work the onus of silence with respect to the business and affairs of the clients of your office. Now, this responsibility, this onus has many phases, many facets, and what I would like to do, and pardon me if I'm telling you, I know I'm telling you things you already know, but it's useful, I think, to gather these things together and spend a few minutes thinking about them. If I were talking to 200 lawyers, I would do exactly the same thing as I'm going to do in the next few minutes. The first thing to remember is if the lawyer is going to do his job, and if you are going to fulfill your role in the delivery of legal services, you have to accept the fact that there can be no secrets between the client and the client's lawyer. If the client withholds information, the client impairs the ability of the lawyer to render proper service. So this is a very open relationship, and because it's an open relationship, all the secrets are known and in the file. Now, in that kind of situation, the client has to feel secure. If the client doesn't feel secure, then the client-solicitor or solicitor-client relationship is not going to work. And the client has to know that the secrets which he or she is revealing are going to be held in confidence by the lawyer and by everyone in that office, and of course, that everyone includes you, the legal secretary who has full access to those secrets. Now, the lawyer, of course, in performing his function, her function, has to reveal some of those secrets in one way or another, has to use those secrets to be effective, but only in part. And that is a judgment call which the lawyer, your principals, are called upon to make. You are not. With you, the onus of silence is complete. You don't have to reveal secrets, and you don't have to make a judgment call as to whether or not you should talk about anything in the client's file. So I think you have, only in that respect, and I think it's the only difference between your responsibility of confidentiality and your principal, is that with you, you know that you don't have to reveal a thing to anyone, and there it is. Now let me talk about some of these things. Is the client entitled to be protected against being identified as a client? My answer is yes. If Mr. A is mentioned at a social function, if his name comes up, and you recognize that person as being a client of your office, you should not say, oh, Mr. A is a client of our office, or Mr. A was in the office last week. It may be that somebody listening knows something more about Mr. A than you do and can identify a set of circumstances which, well, the person begins to wonder why Mr. A was in his lawyer's office. Mr. A doesn't need to be identified, and you should keep secret even the fact that he's a client of your office. Now, let me take a couple of obvious examples. If Mrs. M is consulting a lawyer whose practice is in the field of divorce and family law, Mrs. M is entitled to secrecy as to that fact. If she wants to tell anybody, she can, but nobody else should tell. You may have a person who's engaged in, the example I used was the wholesale hardware business. If that person consults a lawyer whose preferred area of practice is bankruptcy, that person is entitled not to have it said that he has been to that lawyer. It's not a big thing, but think about it. The identity of the clients of your office is part of the client's secret. Now, this duty of confidentiality extends, without exception, to every client, not just to the regular and long-standing clients, but if somebody is once in your office, that person is a client, and the duty extends as well to that person, however casual the relationship between the person and your office is. It is also a duty which outlives the solicitor and client relationship. When the person ceases to be a client of the office, they're still entitled to the protection that they had as a client, and the duty lasts, the duty of confidentiality about that person's affairs lasts forever. Now, perhaps another obvious thing, but one which is important, is that you may not use information which you gain from working in a law office for the economic advantage of yourself or of anyone else. In corporate work, obvious thing, share values and things which are going to affect share values have to be known in the law office. Property values. If somebody is putting together a land assembly plan, you're not entitled to run out and buy a little piece of this property, which is obviously going to have more value than it otherwise has on the market. This is a very important thing, and one which has arisen in many situations. You should not, by any hint or allusion in casual conversation, make it known or suggest that you know something that is affecting the value of any property, of any share, or of any commodity. A few years ago, we had a case in the Supreme Court of Ontario. I'm sure some of you remember. It was one of the longest trials. I'm not sure whether it was the longest, but it was one of the longest trials which ever took place. Now, the outcome of that case was going to determine the ownership and entitlement to mining claims of very immense value. The lawyers, the legal secretaries, the legal assistants, everyone who worked in that case knew things which put them under a terrible onus, when I say terrible, a heavy onus, a very heavy onus of silence. They lived up to it. And the case was under great security. We had, it's before the more recent days when we needed police, but we had police in the corridors and in the courts. And the onus of confidentiality in that case was adhered to. I describe it only as an example of the kind of situation, but every file you've got in your offices today has secrets. And the economic result which can flow from those secrets has to be protected. Now, let me turn to a different situation. No, the practice of law is concerned with every human frailty that exists. And we have things in our files which are interesting, boring. We have the bizarre, the traumatic, the tragic. We have everything in our files. And it's tempting to lawyers, I've heard it done. It's tempting to lawyers and to legal secretaries to talk about a set of circumstances which makes good conversation. It's fun, really, to talk about and think about. And in doing so, if we do it, we protect identities and we change the time and the place a little and we make it seem, but the rule against confidentiality says you must not use a set of circumstances, facts out of a file as the subject of social conversation, because somewhere among your listeners there may be someone who recognizes the facts, notwithstanding the changes that we have made. And that someone may be able to identify the actors in the story, and indeed to identify the client of your office as being the central actor. So we must not tell stories which are based upon the circumstances and facts of a file. Remember this, the story is that of the client, and if it's going to be told, it can be told only by the client and not by us. Now, what about the case where the file, the facts of the file, the facts of the case have had broad coverage in the press and other news media? Happens often. You still should not talk about it. The fact that you may feel the case is a matter of public knowledge does not relieve you of the duty of confidentiality. It may be impossible for you to distinguish between what you have heard on TV, what you've read in the press, and what you know from the file. That's a pretty difficult distinction to make. And that situation doesn't change even because you read the newspaper or listen to the national news and realize that what you've read or what you're hearing is dead wrong, that the facts are quite not the same, and that the true facts have been misstated. It's not our role to correct or amend bad reporting. The moment we attempt to do so, or try to do so, we reveal what patently the press or the news media didn't know. They didn't know the truth, or if they did know it, they chose to report it badly. And the moment we do so, we're in breach of our duty of confidentiality, so don't try to correct mistakes in the news. Now, in litigation especially, you shouldn't discuss the contents of pleadings, affidavits, or other court documents, even though we all know that those are on file in the courts and they're available to the scrutiny of the inquisitive who want to get at them. The fact that secrets may be known and made available by other means doesn't relieve us from the responsibility of not revealing them. Our responsibility of confidentiality continues even though what we have to hold in confidence may be made known through others' lips and by other means. Now, again, in something that applies particularly to litigation, the identity of witnesses. I think you probably all know that on an examination for discovery, my client doesn't have to reveal the name or identity of a witness on which we are going to rely when we get to trial. You should not reveal that a certain person has been interviewed in your office. Not a client, but somebody who's come into the office to be interviewed. That person is probably being interviewed because that person is going to be a witness. Someone listening to you may recognize that, oh, that person has a connection with a case and I know something about that case, and you've blown the cover if you've said that person was in the office. Remember, the names and identity of witnesses is part of the client's secret, and a secret which we must protect. Now, in summation, let me put it this way to you. The office world in which you live and function is one place. The world outside your office is another place. And what takes place, what you learn inside your office is not part of the world in which you live outside. And the secrets of the office must stay in the office. Now, I can conclude this pretty quickly, and I can tell you this, that on April 7th, I looked at the date, last year, we had at the University of Toronto Convocation Hall a special call to the bar, a special convocation for call to the bar of graduates of last year's class. And on that occasion, convocation was addressed by the Right Honorable Sir Robert Edgar McGarry, Vice Chancellor of the Chancery Division of the High Court of Justice of England and Wales. Now, Sir Robert McGarry spoke well, as I would expect, and said, I suppose, to the candidates for call to the bar, the kinds of things which very appropriate to persons entering the practice of law. Among other things, he spoke about this rule of confidentiality, and in a very few succinct words, he said all that I've said in the last several minutes. What he said, now he was speaking to persons being called to the bar, but what he said applies with equal force and equal meaning to each of you. So let me conclude by reading what he said on that occasion. Fourth, there is unbreakable confidentiality. In your career, you will hear much in professional confidence that is of public interest and value. You may learn about what Mr. A has been up to with Miss B, or for that matter, with Mr. C. You may be told details of some large corporate merger, which, when published, will produce striking changes in share values. Yet everything that you learn in professional confidence will remain locked in your bosom until you are released from that confidence. If you meet Mr. A, Miss B, or Miss C socially, not a flicker of an eyelid will suggest to anyone that they and their lives are not entirely unknown to you. It is unthinkable that by nods or becks or wreathed smiles you should allow anyone to have an inkling that any merger is even in contemplation. You will tell nobody, even in the strictest confidence. With your own secrets, you may do as you wish, but these professional secrets are not yours, and you must do nothing with them save preserve them inviolate and unused. If anyone is a blabmouth, the sooner he's drummed out of the law, the better. You will, of course, hear many confidential matters openly within the four walls of the office, but this openness will not deceive you into thinking that what is open within may be treated as open without. Now, those are my remarks on confidentiality. I now have a quick but pleasant duty to perform, and that is to introduce your chairperson, who has worked hard and well in putting this program together, and that is Mrs. Adeline Harrison. I'm going to ask Mrs. Harrison to come up and sit here while I say my next few things. Now, Mrs. Harrison has had a very active and interesting career in the law. For some 13 years prior to 1975, she worked with Mr. Justice Peter Corey, who sat for a number of years on the High Court of Justice, Supreme Court of Ontario, and is more recently a member of the Court of Appeal of Ontario. For 5 years, Mrs. Harrison worked with the firm of Messrs. Morris, Bright, and Rose, and for the past year and a half has been with the firm of Messrs. Goodman and Goodman. Mrs. Harrison is a past president of the Metropolitan Toronto Legal Secretaries Association, Canada, and is a member of the National Association of Legal Assistants in the United States. She worked with Mrs. Rachel Knox, Assistant Director of the Bar Admission Course, in the preparation of material for a publication, a book, Guide to Litigation Forms and Procedure, and Mrs. Harrison is co-author of the Legal Secretary's Assistance Manual. I said she has worked very hard and long on this program, and it's my pleasure to pass the microphone over to her and let her take on for the balance of today.
Thank you, Mr. Collins-Williams, and thank you for those kind words. I'm sure there are no secrets left now, except I'm sure my secretary will have a few to tell you. Welcome, everyone, to the program Litigation for Legal Secretaries. It's been my privilege to work with Mr. Collins-Williams in preparing the program, and when he first approached me, we both decided that this is the third time round for litigation secretaries programs, and we needed to make some amendments to the previous format. We hope that our choice of topics for today will result in your favorable response. Theodore Roosevelt once said, Every man owes something to upbuilding of his profession. And the following quotation, although it comes from the code of the National Association of Legal Assistants, is as equally important to you as legal secretaries. A legal assistant shall strive for perfection through education in order to better assist the legal profession in fulfilling its duty to make legal services available to clients and the public. And while today we have some of the same old facts, tried but true, we do have new faces with different approaches who will be explaining to you the particular aspects within the overall workings in the field of litigation. My comments and introductions will be kept to a minimum in order that we may provide you with ample time for the speakers to go through the respective papers. By way of very general introduction, I would like to say that each of our participants today is a barrister and solicitor. And as all of you who work in litigation know, priorities alter our commitments from day to day. And much as the original cast of speakers wanted to be with you today, and what lawyer would give up the opportunity of addressing a room full of secretaries, there are two changes to our list of participants, and those will be announced as I introduce the speakers to you. Those are my words of introduction, and now to get the show on the road, our very first change. C. Clifford Lax, QC, of Goodman & Goodman, could not be with us this morning. Regrettably, he opted out for a business trip to Ireland and England. However, as every litigation lawyer knows, you always have a standby or an understudy. And we have with us this morning Alan Channoff of Goodman & Goodman, who will speak to you on the organization of a litigation file. Mr. Channoff was called to the bar in 1978, having articled with Goodman & Goodman, and has made his career in the litigation section of that office. Mr. Channoff's practice comprises of a great deal of work in wrongful dismissal, so I'd better be careful, libel and slander, and in addition, he does find time to find faults with my writs of foreclosure. I would like to introduce and call at this time Alan Channoff, please. Oh, I think it's the wrong way. It has to go this way. It can be heard. Okay.
Thank you, Adeline. I have the dubious honor of taking Mr. Lax's position, if anybody can. My topic is organization of a litigation file, and you might at first blush think, why is anyone taking the time to talk about such a topic? Well, I'll tell you why. First of all, even though it may take some time in organizing a file properly in the first place, in the long run, it will save both you and the lawyer time if you do get it organized in the first place. Second of all, it's not unusual for another lawyer to take over a file in the same firm because of a business trip that the first lawyer has to take, because of a trial that may be called, because of illness, whatever. A second lawyer may have to take over the file. If the file has not been organized properly, it will be much harder for that second lawyer to take over the file. Third of all, documents often can get lost, but if a file is properly organized, they won't. Fourth, proper organization of a file can help to win cases. If the file is organized properly and all the facts are at the lawyer's fingertips, then it will be easier to organize the case for trial, and it will be easier to win the case in the end. Fifth, the last reason, but perhaps the most important reason, is that organization of a litigation file properly will avoid negligence actions against your law firm. Now, I've spoken to, or I've heard several adjusters who deal with claims against law firms speak about this area, and everybody says that when you get a file from a law firm who is being sued, the first thing you will notice is that the file is not organized. It's simply a morass of documentation with no order to it whatsoever, and those are the types of files from which negligence actions against law firms spring. Therefore, organization is important. Now, the first thing to remember about organization of a file is to keep separate files for each matter. The practice of having a general file for a client is a poor practice. Even in our firm, you will see files opened for Client X, re General Matters 1983. That is a bad practice. You should have a separate file for each matter, for each client, because in the future, after you've closed the file, if you ever have to retrieve the file, you won't be able to find what you're looking for unless you have a separate file for each matter. Also, when it comes to billing a matter or having your bill taxed, if you don't have a separate file for each matter, then your docketing will not be organized properly, and therefore your bills will not be appropriate, and you will suffer when your bills are taxed, either on a party-party basis, i.e. when the other side of a case is to pay the account or a portion of it, or on a solicitor and his own client taxation, i.e. where your client taxes your bill or you are trying to collect on your bill. After opening a file, or indeed before you open the file, you must check conflicts of interest. Each firm will have its own system of checking conflicts, and you may simply have a master list of clients in a central area, or you may have this on computer, I don't know. But before you actually open a file and go off issuing writs, doing whatever you do in terms of demand letters, you should make sure that you don't have a conflict, because it's very embarrassing to find that you are suing a client of your own firm. It's even more embarrassing if you find out that the other side was a client and you have confidential information which you cannot use. Therefore, you get in the embarrassing position where there's a motion to have your firm removed as solicitors for record. After checking conflicts, you should be checking limitation periods. In virtually every litigation file, there is a limitation period. By that I mean a period in which if an action is not commenced, the rights of the client will be lost. When I say lost, they're not lost entirely, because the client will have the right to sue your law firm if the limitation period is missed. In most cases, limitation periods are 6 years. However, in motor vehicle cases, they're 2 years. And when you've got a governmental authority involved, it's often 6 months. In some cases where you're dealing with municipalities, the limitation period, depending upon the cause of action, can be anywhere from 7 to 30 days. But the point is that when a file is opened, you must find out what the limitation period is. And I don't mean that you have to go and scurry around to try to find the answer, but that should be a question put to the lawyer. What is the limitation period? The reason you put that to the lawyer is because you will have the duty of maintaining a diary or tickler system. Under the rules of professional conduct, you must maintain, every law firm must maintain a separate diary or tickler system with respect to limitation periods. And in most cases, it's up to the secretary to maintain that system. It should be an independent system. That is, it should not be part of the file. There should be a separate diary kept for limitations or a separate tickler system kept for limitations. And indeed, in some firms, a third person, that is neither the secretary nor the lawyer, keeps that diary or tickler, but another body in the office will keep that system, and it will be his or her job to remind the secretary and the lawyer of a pending limitation period. We've now got to the stage where the file is opened, you know that there's no conflict, and you know what the limitation period is, you've set up your diary. The next thing you have to consider is pigeonholing. Lawyers are very good at putting things in pigeonholes. We don't think in abstract terms, we think in concrete terms, in terms of where does something fit in? Is it a breach of contract case? Is it a negligence case? What is it? And then we find the right rule. Well, when you're organizing a file, you have to pigeonhole the types of documents that you have. Each document should be filed in a separate subfile. Indeed, in our litigation department, we even use color coding to determine the type of document. And so pleadings, for example, will be in a separate color-coded file. The client's documents will be in a separate color-coded file. There are many types of documents that you will have in a file. The first is general correspondence. All general correspondence should be kept on a brad in chronological order. Chronological order is very important because when you look back at a file, you may be looking for a letter of February 1, 1980. Well, if you're going back in the file and the correspondence is not in chronological order, you won't find the letter. You'll think it's lost when it isn't. It's simply been misfiled. Accounting information, that should also be kept in a separate subfolder. By accounting information, I mean copies of the firm's accounts, copies of bills that the firm has paid, i.e. monies that have been dispersed. The dockets that are being kept should be kept in that separate folder as well, so that at the end of the file, or if you're interim billing, you can simply pull out the subfile and know what the client has been billed, know what the disbursements are since the last billing, and have a record of all of the time since the last billing. It'll save you a lot of time, not only in terms of billing, but when you have to prepare a bill of costs at the end of a case. It will save you time when you have to tax your costs. So you should have all of the accounting information kept separately. The third area of documentation is comprised of transcripts. They might be transcripts of cross-examinations, examinations for discovery, examinations de beni esse, which are simply examinations of parties before trial because of various circumstances. Those transcripts must be kept in a separate subfolder so they don't get lost. And any undertakings or responses to undertakings should be kept at the front of each transcript. You'll also from time to time be getting documentation from your client. That documentation is very important. You mustn't write on it. You can write on copies, but not on the originals. When you receive documentation from the client, of course it has to go in a separate subfolder. It can't be mixed in with any other documentation because in every litigation matter, there should be an affidavit on production listing all of the relevant documents. So you must know what documents come from your client. If you mix those documents in with the documents that have come from other sources, the affidavit on production will be false, and someone will be swearing a false affidavit. As you get in documents from your client, you should put them in order, usually chronological order, and you should be preparing a typewritten list of the documents as they come in. That will take time, but when it comes time to do the affidavit on production, you'll find that you can do it much faster than you otherwise would have been able to. Next category of documentation is documentation received from the other side. Again, it must be kept separately. You cannot mix it in with your client's documentation, or otherwise your affidavit on production may end up being false. There will invariably be copies of cases or memos of law placed in the file. Again, they have to be put in a separate subfile because when it comes time for a motion or a trial or indeed settlement negotiations and the lawyer needs the cases and the law at his fingertips, he has to have it in a separate, he or she has to have it in a separate subfolder. Otherwise, the research is simply going to have to be redone because it will have been lost. There will also be witness statements. Again, they have to be kept separate. Witness statements are usually taken at the beginning of a case, and often a case won't come for trial for 2 or 3 years. It's easy for witness statements to be lost if they're simply shuffled in with a general correspondence or whatever. They must be kept separately. In the motor vehicle type of litigation or in other types of litigation, you might have medical reports or medical documentation. Again, they have to be kept separate. They're important documents because when you come to trial under the Evidence Act, lawyers may simply serve a notice and then do not have to call the doctor to the trial. They can simply put in the medical report as evidence. It's one of the exceptions where you don't have to call the actual body to trial. You can put in a document. There will also be pleadings. They must be kept separately. At our firm, pleadings are supposed to go into a separate black binder. There's to be an index sheet at the front of the black binder, and that black binder is kept in a red folder so that you can always find your pleadings brief. The reason that's done is so that when you come to trial or to the pretrial hearing, you will have a trial brief all ready for the lawyer without having to take the extra time to prepare one, because your pleadings brief will virtually be a trial brief. You may need another volume for the trial brief, which would be comprised of transcripts, witness statements, medical reports, other documents of that sort. But you can see if you've kept your file organized from day one, you will virtually have a trial brief prepared at every stage of the action so that you won't have to spend the time, the hours of going through the file to prepare a brief before the pretrial hearing or the trial. The point I'm trying to make in terms of pigeonholing is simply that every piece of paper that comes into the file has to have a home. And a good file, a well-organized file, will have a large number of subfiles in it. Each subfile will be separately marked. There's no point in having a color-coded scheme or using subfolders if each file isn't marked. And then you have to make sure that you use a system. There's no point in having the system and then filing documents in the wrong folder, or as some people will do, simply putting whatever comes in at the front of the file. That won't work. And it's very important for the reasons I stressed at the beginning of this talk, and that is another lawyer may have to take the file. Things may happen. You never know when you need the file organized properly. And again, as I said, most negligence actions against firms arise in cases where the file has not been organized properly. So much for organizing a file. I'll spend a couple of moments on time savers. Each office will have its own system for saving time. A few of the suggestions I've already made will help you to save time. For example, if you've used the proper system of organizing your file, you'll have your trial briefs ready ahead of time. That's a time saver. You will have your list of documentation received from the client on an ongoing basis. That will be helpful in putting your affidavit on production together, again a time saver. You should use master sheets for back pages of pleadings or styles of cause. There's really no reason why anyone has to type a back page or a style of cause more than once. You use a master sheet and you can always run off more copies. You don't need to retype that. At our office, we use a stamp for an affidavit of service. And you can see the form of stamp in the material. And what the secretary does is simply put the stamp at the back of any document that must be served and filed. And the stamp is a big time saver because the secretary simply fills out some of the information on the stamp, gets it sworn and commissioned, and the document can be filed. Form letters. This is something that U.S. attorneys use a lot more than Canadian lawyers use. You should work up a system of form letters. There should be a separate form letter, for example, that would go to new clients in motor vehicle cases, new clients in other types of cases, a form letter that would go with bills. You should have separate form letters that go out from time to time, and you don't really need to prepare a new letter each time if you've got samples or forms done. The real estate department of our firm is excellent in that respect. They have separate form letters that go out to all the proper places, for example, the municipalities, hydro, consumers, gas, whatever, and they don't need to use any original thought because they simply use form letters and send the form letters out to the appropriate bodies. Well, you can use that with your own clients. You can use form letters, and to the extent that you find yourself typing the same letter over and over again, get a sample and use that. And if you have an AES system or a computerized typewriter, again, store sample letters so that even if you have to make changes, it's a very simple matter of making simple changes. That's about all I have to say on time savers and organization of a file, but I'll close in just pointing out, and my secretary isn't here so she won't mind me saying this, but when she's not at work because she's ill or on holidays, I don't mind it too much in terms of the typing that does or doesn't get done, because anyone can take her place and type the documentation for her. However, what I really miss is the fact that when she's been gone for a week or two, the organization of my files is in a shambles, because it's very difficult to get a temporary person to know your system and use it. And that just shows how important it is to have a litigation system which uses an organized fashion of keeping your files and making sure your files are kept in an organized manner. Thank you.